Alright, part 2, real estate brokerage. Agency law, essential matters to learn in this chapter. The agency relationship involves the two parties, principal and agent. Principal is the property, the owner's property, the employee of the agent to locate with the buyer and leaser, or a party who employ with the agent with the line with the property to buy or lease. The person who earns the license to be a real estate broker, the meeting, educational testing experience requirements that are set by each state of the real estate broker legally serves as an agent or for the principal, the real estate principal, the special agent of the principal. For the principal, cover the agent powers are limited to the contract for the general agent. They also cover the universal agent, who is entrusted with the principal with the broader powers to act for him. Real estate brokers may be employed, licensed, and salesperson to do assist with the performance of the role. Typically, the salesperson must meet licensure requirements. The education testing with the broker, the responsible for the acts of the salesperson. He employs sales and sub-agents of the broker. The realtor is the broker, salesperson, the member of the National Association of Realtors, which is a trade association. National Association of Realtors provides educational training with economical data, political lobbying. It's no stated agency that does not offer a license to sell real estate belonging to others. Broker typically represents single party, either buyer or seller of the transaction. The broker owns the fiduciary duties to the party with all the fiduciary, one party, single agency relationship. Broker must deal honestly with the other parties in the transaction. As a fiduciary with the broker, they must deal with honesty and fairly, be loyal to the obey of the principal, instruction, protect confidential matters of the principal, provide full disclosure to his principal, properly account with the funds, observe skill and care present all offers in a timely manner, disclose all known material facts of the property within his value except those that are readily observable. Broker may not obey principal requests, is legal with the particular interest of the requirement to follow fair housing law and not violate anyone's civil rights. Single agency broker is the owner that must not tell the prospective buyer the owner is desperate to sell with a lower price because he is getting a divorce. The personal matter of the broker must be honestly answer buyer's question with the condition of the property to extent with the knowledge because the buyer is interested in buying the property. This is different from the answering the question about the personal matters of the owner, which the buyer does not acquire. Dual agency occurs when the brokerage firm represents opposing parties with both buyer and seller with the same transaction statement that allow the dual agency with both principals understand the situation, receive the disclosure often required to be in writing. But professional behavior expected with the dual agents include honesty, skill with the care of the accounting funds for the representation of the offers. Transaction broker occurs with the broker does not represent either party, but instead provides services with the general information to either party without looking out with the interest of the particular party. No brokerage agency may occur when the party transaction have reached an agreement but seek help as so how to will the fill out with the contractor with the sale with the disclosure should be provided with both parties so all can understand and agree with the broker's role. Listing with a contract between the principal and the broker that they offer the real estate for the sale with many states require a listing with a writing of the broker to collect commission. Many of the states require the listing with they have fixed expiration date. Listings are explained more in detail chapter 11. Brokers earning commission when he or she brings ready for the willing and able to buy with the seller terms set forth the listing. If the owner decides not to sell, the owner still owes the broker a full commission. Opening a listing often used with a high value commercial property gives the owner the right to the list of the property with more than one broker. The broker who sells the property earns the commission. The exclusive agency listing allows only one broker to sell by the owners may sell through his efforts without paying commission. Excludes the right to sell listing provides commission to only one broker, and even if the owner himself makes the sale. Multiple listings serve as the MLS, a local organization which many of the brokers participate. Typically, listing brokers bring the listing of the pool through the listing with known as members. Listing brokers usually share the commissions of the selling broker. Net listing is one of the minimum selling prices specified by the broker. Commissions amount above the net price specified by the net listing is frowned upon illegal in most states because some of the contracts for sale of the broker interest may be opposed to the owner. We determine an agency relationship with death and income of either party, bankruptcy, either party, destruction of the property, performance of the contract, expiration of the contract, mutual agreements of the parties, resignation of the agent that may require the payment of the damages, and 8, discharge the agent by principal. Principal may be liable for the damages. Commission rates are set with a negotiation between the principal and the broker. The Sherman Antitrust Act prevents broker from price fixing. You can apply monetary penalties, prison terms for the brokers who agree to fix commission rates. Be sure to study Chapter 11, Listing Property Management, on Chapter 20, Fair Housing Laws. A licensed real estate broker, the salesperson, the agent of the principal, therefore the real estate relationship that comes from the law of the agency. He or she is effective with a real estate license of the law of the state with the topic will be discussed in Chapter 5. The agency relationship involved with the two-party principal and agent for the agency relationship with the contractor, but also cover the requirement of the agency law with the real estate business broker acts with the agent of his power with the principal who is owner of the property with the broker with the seeing buy and attend with a potential buyer and a lease with a licensed salesperson usually treated as an agent of the broker because the license does not permit the salesperson to act without a supervision of the broker. The real estate broker is a special agent. He's called this because his powers are limited and usually to find someone to whom the principal can be deal. By contrast, general agent, also called the universal agent, of the person who with the power of the broader may extend it so far as the commitment to her employer to action. Note, real estate broker usually has little or no power actually to commit the principal to anything. The principal may refuse to deal with anyone the broker brings to him, although he or still may be liable for the broker commission if it has been earned. Duties of the parties. Agent is employed by the deal with a third party for the behalf of the principal. The agent is employed by the principal. The must follow the people's instruction implicitly, unless with doing so will result in the violating of law. Furthermore, has the duty of acting in the employer's best interest, and even when doing so, the means of the contact to act in his own favor. The most specifically, agent laws require that the agent abide with the following obligations to his principal. He must obey the principal's instruction, except for the course when instructed to do so illegally. He must be loyal with the principal interest. He must act in good faith. He is expected with the professional judgment, skill, and ability within his actions. Particularly true in the case of licensed agents such as real estate brokers who assume to have to meet certain standards by virtue of having to be licensed. He must be able to account all money belonging to others that comes into his possession. Real estate brokers often collect rents and earn money deposits of their money on the behalf of the principals. He must perform his duties in person. Normally, this would mean that he cannot delegate the duties with anyone unless the principal approves of the arrangement. Because of the nature of the real estate brokerage business, the establishment of the broker-salesman relationship by all state licensed law, real estate broker has implied the right to delegate the function duly licensed salesperson and other brokers to his employee. He must keep his principal fully informed of the development affecting the relationship with the real estate broker. The must report all offers made for the principal property as well as other information acquired that may affect the principal property price or other relevant factors. Principal of his obligation to agents as well. Many of these have to do with money. Principal obligated to compensate by the agents for the services with reimburse the agent for the expense paid on the behalf of the principal and secure the agent against the loss of the due paper prior to the performance of the duty. Principal also implied with the duty to make agent fully aware of his or her duty to inform her fully about anything that will affect their performance. Real estate agency contracts. Agency contracts are employment contracts. Consequently, do not come under the broadening heading of the real estate contract, but not necessarily required by the statute of the frauds. If they be writing, Chapter 6, many state with the real estate licenses do require listing with the contracts in writing to be in writing. The real estate agency, the contract usually is called a listing. The detail of the drawing up these contracts is discussed in Chapter 11. However, we can briefly distinguish among the various kinds of listing. Any among listing of the property sale of the following: open listing is one with which the prime principal agree with the compensate with the agent only over the agent actually finds the buyer with whom the principal finally deals with. A single owner may have the opening list with many broker since she of the obliging herself to pay only upon performance of the broker makes his effort on his own risk. Exclusive agency list is one of the principal agrees to employ with no other broker. If the property is sold with any licensed agent, the commission will be paid with the license of the broker. State license usually requires that any other agent must work through a broker having an exclusive listing. In particular, participating broker must then agree on means by which they are sharing commission. The commission will be able to always be paid with the listing broker, who then may pay a share to the other broker who are cooperative with the sales transaction. The broker may then pay a share of licensed salesperson employed. The scoop of the right to sell with a guarantee with the principal will pay with the broker with the commission regardless who actually sold the property applied with even if the principal or herself will find with the pay buyer with no aid at all to the broker. Note, there's under exclusive agency listing where the principal does not have to pay the commission if she finds herself the buyer. Usage of the term exclusive listing with varies from one place to another. Some localities term that refers to exclusive agency often refers to the exclusive right to sell. Still others refer to both the type and interchangeable. A net listing is one with the principal agrees to receive the given amount with excess of which with a sale price exceeds the net amount with the broker to earn as his commission. In many states, the net listing is illegal. In many others, they are not illegal, but are frowned upon, otherwise disapproved in some quasi-official manner. Big problem with the net listing is that the agent strongly tempted to act in his own interest rather than that of his employer. To illustrate some of the net listing contracts proposed, the net seller has $180,000 as agreed upon, but by law, any time the broker solicits an offer must report it to the principal. However, let's assume that if offered exactly $100,080 is made, broker transmitted to the seller property will be accepted. The broker will receive no compensation. Clearly, there is the temptation to illegally hide the offer to any subsequent offers until one yielding a satisfactory excess over the listed prices received. Such actions contrary agency responsibility of his employer. A further source of trouble when net listing arises if the knowledgeable agent deals with a naive seller. There may exist the opportunity for the agent to convince the seller to sign a net listing at low price, thereby guaranteeing the agent a large commission when he finds the buyer who will pay the market value. Or the agency relationship of real estate broker with a listing contract with the agent, the relationship between the owner of the listed real estate with the broker, with the brokerage firm with whom the owner hires the seller, at least the real estate with the this makes sense. However, the real estate with the brokerage business is very common for other brokers to be involved with in transaction. Brokers very often cooperate with one another. They agree that all allow one or other to seek the buyer's attendance at each other listing. Any other broker found with the buyer with the tenant with the listing broker agree with the share with the other broker commission paid for the property owner. The situation leave with the question whom all the agents actually represent. With the traditional agency, all agency involved with the cooperative of the transaction represent only the seller. Of the buyers have no agent looking out for their interest to call with the traditional agency because of this. That this is the way it all was done until about 30 years ago. At the time when the state began to allow buyer agency, a buyer agency occurs with the licensee. The licensor specifically represents the buyer within the contract to the effect that the sign of the way the buyer gets the agency representation professionals looking out for their interest of the buyer agent to compensate with the share of the commission paid by the seller just in a traditional agency. The most recent, many of the states have created a non-agency broker arrangement with the license. There isn't really an agent at all, but the buyer and the seller have to look out for themselves with the broker just to assist in showing the property move the transaction along. Most states are now allow the buyer agent the situation, licensed broker, salesman, agent of the buyer with the referred rather than the seller in such situation, loyalty with the license to the buyer rather than the seller. The states now allow the form of the agency to order the provided means where the buyer receives the same agency loyalty service as always has been enjoyed by the sellers. Buyer agencies also allow licensors to engage in the selling of the process more effectively because they are not restricted to information and advice that they can give to the buying prospects. Many states now require agency disclosure by real estate broker upon the first contact with the prospective buyer. The broker must provide notification that he actually represents the seller, but does not look out for the specific needs and interests of the buyer. Usually the law specifies that a certain form that must be given to the buyer, and the broker cannot be proceeded with any of the dealings for the buyer until the broker has received from the buyer a signed acknowledgement that the buyer, in understanding the agency relationship that the broker has with the seller. Single agent relationship. Single agent relationship. The agent may represent either of the buyer or the seller. The broker agent owns fiduciary duties to the paid representative must disclose these in writing. The residential transaction fiduciary duties or single agent principle include dealing honesty, fairness, loyalty, confidentiality, obedience, full disclosure, accounting for all funds, skill care, diligence in transaction, presentation of all offers, counter offers in a timely manner unless the party has previously directed the licensor otherwise writing, disclose all known facts materially affect the value of the residential property whether or not and readily observable. Dual agency. Suppose the real estate agency has contracted the agent's prospective buyer that they begin to show the property to the buyer. Suppose all of the agents will show the buyer of the property that the agent, him or herself, or the agent broker firm has listed. In this case, the agent would become the agent of both parties of the transaction. Clearly impossible to have absolute loyalty for the interests of both parties, meaning that had been divided with the license to proceed into the situation. Most states now allow dual agencies in such cases that some of the states prohibited practice in order to solve the problem representing both sides of the transaction. Dual agency disclosure to be representative is agreed to by both the prospective buyer and the owner of the property to show if the property to all agree to the license agency relation, both the buyer and seller will be limited to if now to compromise the interest of the either. Typically, the dual agency discloses that at very least the agent can reveal the seller with the highest price for the buyer will pay, but cannot reveal for the buyer the lowest price the seller will accept. Dual agency solution when they allow for the license to show the property in question, it does the limiting agency obligation of both parties. Therefore, some of the state of the tradition trying variation dual agency is required instead of the different license step in the situation to represent one of the parties fully, while the original license continues to fully represent other parties. party transaction brokerage. Many states have adopted the form of the brokerage of the transaction brokerage, also called facilitative brokerage, and a few states with the transaction brokerage signs an agreement that either with the buyer or seller or both, stating that the broker does not represent the interests of either party, but merely provides the brokerage service with the general information of both parties. Business with the buyer and seller are their own respect looking out for the interests in some state of the duty of the transaction, which are disclosed for the residential transaction, are dealing honestly and fairly, accounting for all the funds, using skill and care to diligence in the transaction, disclosing all the known facts of the material effect of the value of the residential real property are not readily observable to the buyer, presenting all offers of the counter offer in the timely manner unless the party has previously directed the license or otherwise in writing, likely confidential unless waived by a written party with limited to confidential, preventing disclosure. The seller will accept the price less than the asking listed price of the buyer, will pay the price greater than the price submitted with the written offer. The motivation any of the parties selling or buying the property, the seller or the buyer will agree financing terms other than those offered or any other information requested by the party remain confidential. Any additional duty to enter into separate written agreement. Know that loyalty, confidential obedience, and full disclosure are not included in the transaction relationship with the seller and or the buyer considered the customer to the broker. The principal, the customer is not responsible for its acts of the broker license. Other states of the transaction broker's relationship is similar to non-brokerage agency relationship as described below. Non-brokerage agency relationship with the buyer and seller will tentatively reach an agreement about seek some help they may engage in the broker with the broker relationship with the broker assistant that needs with the help with the complete with the contract of payment at a fixed fee with the hourly rate rather than with the commission where there is no agency relationship. Duties of the licensor with the habit of the broker agency relationship with the buyer and seller must be fully described and disclosed with the writing of the buyer and seller. The disclosure must be paid before the showing of the property incorporated within the other documents. The required notes must be of the same size, type, larger with the other provision document must be the conspicuous in the placement as so the advise the customers of the duties of the licensor who have no brokerage relationship with the buyer or seller. The duties are dealing honestly and fairly, disclosing all known facts of the material affected with the value of the residential real property that are not readily observable to the buyer, accounting all funds entrusted to the licensed buying brokerage. Buyer brokerage. Buyer brokerage all occurs when the broker enters the contract with represent a buyer. Typically, with the arrangement with the broker owes the buyer a full agency representation, do not represent the seller at all. But in spite of the fact that the typical buyer's broker arrangement, the seller will pay the entire commission to the listing broker who shares the commission agreed with the buyer's broker, and in effect, within the seller ends up paying off the other party's buyer representative, typically listing the contract containing the clause in which the listing owner agrees with these situations or provisions. Most state licenses laws mandate default relations either explicitly spelled out in the law. Implicitly, law does not specifically default the relationship. It's impossible to be able to apply without implying one. This means upon the first contract between the license and the buyer or seller with a certain for the agency relationship exists by the law until they're replaced by another. The nature of the default relationship varies from state to state. In some of the default of the transaction broker, this means that no agency relationships exist until the parties involved agree to one. In some states, the default is sold with the agency. Others have the buyer agency of the default. A key point: everyone involved with the transaction must be aware of the agency relationship after or before the negotiation transaction begins. Exactly when the disclosure of the buyer agency has made with the various among the states. Some of the states require the buyer agency to be disclosed first contract. Contact with the seller or the seller's broker before any after actually might be made. Others allow it to be disclosed when the offer actually is made, usually with accomplishment including language or any offer the contract of the sale, Chapter 8, the specifically state of the broker representative of the buyer, even though the buyer broker of the will share with the commission paid by the seller. Alright, earning the commission under the common law of the broker earns the commission when he produces the buyer with the tenant who the principal that is willing with the deal with the front. The risk of the deal actually will go through the rest of the principal. However, the many of the listing contracts today, but the risk of the broker with the rest of the commission is not payable until the sale closes. As mentioned previously, if the principal does not oblige with the deal with anyone with the broker begins, that is, the principal hiring with the broker inquires no legal responsibility with the third party. Consequently, the buyer is willing to pay the asking price that meets all of the conditions that are set down by the principal in listing agreement and normally will have no legal recourse if the principal refuses to deal with them. Unless the buyer's civil rights have been violated. Nevertheless, the principal obligation of the broker remain listing agreement, acceptable price of the term sale of the special of the broker produce of the bona fide offer that meets all of the conditions the principal liable to pay with the broker commission, even if the chooses not to accept the offer. This is required because the broker has satisfied with the term of the employment of the contract. There is a contract between him and the principal, therefore is no contract however between the principal and the third party, such as the potential buyers. So if the principal is not liable for them, the broker principal to refuse to pay the commission the broker feels have the may see the court may sue in court to receive the access. Success of the broker must have three things. There had that was licensure over the time of the beginning of the solicitation, listing of the closing transaction, passing of the title, notification whether the principal she will not accept the offer that meets the terms of the listing agreement that had the contract employment with the principal with the best evidence that have the written contract. Some of the stating laws requirement of the listing to be written with enforceable. He was efficient with the procuring sale of the sale that he has actually brought the sale within the terms of the listing contract. Open listing would mean that they actually found with the eventual buyer with the exclusive the agency listing. He must have found the buyer. The buyer must have found by a licensed agent exclusive the right to sell them effectively defined the broker have earned a commission when if the property is sold because only one specific broker has the right. Termination of the agency contract. Agency contracts will be determined a variety of events, though some of the relatively uncommon and broad. Some of the contracts terminated with the two-way of the action of the parties of them and by the law of the certain events occur. Termination activities of the parties and found with the contract that terminated performance both of the parties performing the duties prescribed in the event by the agency that created the end of the real estate business. The listing agent contract terminated by performance when it is meeting of the minds between the principal and third party with the found with the agent. Sometimes however, the contract will specify some of the other events, usually title, closing event, listing with a sale as the actual termination contract or relationship. Parties have mutually agreed with the terminated relationship before the terminated by performance agents but may re-sign with it. Even in the case of the agent with the bill may be liable to the principal to damage if due to the breach of the contract. He cannot be held to perform under contract with the principal to discharge the agent with once again with the principal. Two can be liable for the damages due to the breach of the contract, but she can be forced to continue with employment of the agent. The agent may reassign or the principal to discharge the agent without penalty if it can be approved the other party with the properly discharge his or her duties of the contract with the agent justified in re-signing it. For example, the principal did not provide him with enough information to do his job well as required to perform some illegal act in the execution of the duty. Agents could not be discharged justifiably should be shown that it was not faithful to the duties acting contrary to license and interest of principal. Termination contractual relationship also occurs automatically by law with the occurrence of certain events such as the following: death of the either party terminates agency relationship, then party becomes legally incompetent, agency relation ceases, bankrupt either of the parties become a continually relationship, then possible to terminate the relationship. Instructions subject matter to terminate the agency relationship to real estate would include such events as burning down of the house, the discovery of another claim on the title that would make it impossible for the owner of property to pass good marketable title. And that was chapter 4.